Toward the Citizenship Law, Nazi Politics in the Early 1930s. Before turning to the nuts and bolts of Nazi-era investigation of America's immigration and citizenship laws, it is important to set the stage by establishing some context about the goals of the Nazi regime after it took power. In particular, it is essential to emphasize that extermination of the Jews was not the initial aim of the Nazis. In the early years of the Nazi regime, deportation and annihilation were as yet difficult to imagine. The aim that always stood in the foreground was to drive Jews to emigrate, whether through violence on the street or through the creation of legal disabilities. The goals of the early 1930s were nicely formulated by Wilhelm Stuckart, co-author of the standard commentary on the Nuremberg Laws. Stuckart, later a high SS officer, would be present at the Wannsee Conference that decided on the final solution and was eventually tried as a war criminal. But in the early 1930s, he spoke not of the final solution, Endlösung, but of the definitive solution to the Jewish problem, endgültige Lösung. The two Nuremberg Laws, that is, the Citizenship Law and the Blood Law, represent the beginning of the definitive solution to the Jewish problem in Germany. Starting from the recognition that Judaism involves not a religious community, but a community of persons related by blood, a community that is worlds apart from the German folk, these laws and the supplementary ordinances and provisions for their execution complete the legal separation of Germandom and Judaism in the most important realms of life. It has been made forever impossible for Judaism to mix itself, Vermischung, with the German folk, or to get mixed up, Einmischung, in state policy, economic policy, or cultural shaping of Germany. If, according to the principles laid down in these laws, the Jews still belong to the Mutual Protection Association of the Reich and remain nationals for the time being, the definitive solution to the Jewish question can nevertheless only consist in the territorial separation of the Jews from the German folk. That is, the goal of German Jewish policy is the emigration of the Jews out of Germany. Annihilation came later. In the period of concern for this book, the Nazi policy was coerced emigration. We must bear that fact in mind as we try to understand Nazi citizenship law and its relation to developments in the United States. For a regime whose aim was to drive those of supposedly foreign blood to emigrate, citizenship law was centrally important. Correspondingly, after taking power, the Nazis moved quickly to alter German citizenship law in order to disfavor Jews and other foreign bodies. The project began on July 14, 1933, with a law on the revocation of naturalization and the withdrawal of German citizenship, promulgated on the same day as the basic Nazi eugenics statute. The main purpose of this first Nazi citizenship law was to facilitate the denaturalization and expulsion of Ostjuden, Eastern European Jews who had arrived after the First World War. Reich Minister of the Interior Wilhelm Frick described it as the beginning and point of departure for German race legislation, and the next 2 years of debate and pressure consistently emphasized the fundamental role of citizenship law, culminating in the Nuremberg Citizenship Law that definitively assigned Jews to second-class status. And it is an unpleasant truth that throughout this effort to degrade, demonize, and expel the Jews of Germany, American law remained a regular Nazi point of reference, just as it had been for Hitler before. America remained the leader, and the Nazis repeatedly turned to the American example when developing their own immigration and citizenship law. After his ascent to the chancellorship, Hitler himself ceased holding forth on technical legal questions, but leading Nazi jurists and functionaries picked up the thread, maintaining a steady and regularly reiterated interest in American examples. An important early example is Otto Koellreutter, perhaps the most eminent Nazi public lawyer in the early 1930s. A sympathizer of the Nazis from 1930 onward, Koellreutter formally joined the party on May 1, 1933, the same day that Carl Schmitt joined. In that same year, he was given a chair of public law in Munich, the home city of the Nazis. He served in leading academic positions as journal editor and the like. In late 1933, this high priest of juristic Nazism published a book intended to lay out the basics of public law for what the Nazis were calling their national revolution. Public law included immigration and naturalization, and when Koellreutter came to that subject, he devoted a long discussion to the American example. He began by touching on the British dominions as well as the United States. As Nazi writers noted, the British imperial world had unwritten social laws against race mixing, which they certainly found of interest, and a few formal laws as well. The Nazi interest in Anglophone traditions deserves to be flagged. The Nazis were drawing on practices that had developed in the broader historically British world, not just in the United States. Still, what intrigued Koellreutter most was the legislation of America. He wrote, "A further necessary measure for maintaining the healthy racial cohesion of the folk lies in the regulation of immigration. In this connection, it is above all the legislation of the United States and of the British dominions that has yielded interesting results. Worthy of attention above all is the development of immigration legislation in the United States. Until the 1880s, a liberal, freedom-oriented conception led the United States to regard itself as the refuge of all oppressed peoples, and consequently limitations on immigration, to say nothing of bans on immigration, were considered irreconcilable with the free Constitution. This conception very quickly changed. 1879 witnessed the first bills aimed at banning Chinese immigration. However, it was above all after the World War that American immigration legislation embarked on an entirely new path. Today, that legislation represents a carefully thought-through system that first of all protects the United States from the eugenic point of view against inferior elements trying to immigrate. Regulations targeting physically inferior and unhealthy would-be immigrants are applied strictly and even harshly. Alongside eugenic measures is the establishment by law of certain immigration quotas. For the World War awakened American consciousness to the fact that it is by no means the case that all immigrants can be melded in equal measure into the originally Anglo-Saxon population, and that a fully free immigration policy must inevitably endanger the stamp of the national American type. So came into being in 1921 the first quota law, in which each European country was credited with a certain number of immigrants, and indeed no more than 3% of the number of immigrants from the country in question who had settled in the United States in 1910. So, for example, in 1924, there were 165,000 immigrants, among them 62,000 English and Irish, 51,000 Germans, 3,845 Italians, and 2,248 Russians, including the East European Jews. In the last several years, immigration has been even further limited. Two observations about this passage are warranted. First, it was carefully researched. As this and other passages soon to be quoted show, Germans were giving studious scholarly attention to American immigration law. Second, it is impossible to characterize what Koellreutter wrote as intended for foreign consumption. Scholars who want to claim that Nazi references to American law were simply attempts to cite vaguely relevant precedents for homegrown statutes and policies to deflect criticism are simply wrong. Some Nazi writings can possibly be dismissed as efforts to deflect criticism. But Hitler was already praising America well before the Nazis took power. He could hardly have been aiming to counter bad press for a regime that did not yet exist. The same is true of Koellreutter. He published his book in German, a language that few foreigners found easily accessible, and following customary Nazi practice, he published it in Facto, a script that foreigners without a strong command of German find irritatingly difficult to decipher. There is nothing propagandistic about the tenor of his text. There is no sign that Koellreutter's book, which would become a standard citation in Nazi Germany, stirred any attention whatsoever abroad, and no good reason whatsoever for supposing that it was aimed at polishing Germany's international image. Koellreutter, as the leading German public lawyer, was engaged in a lawyerly study of a subject important to Nazi policymaking in the dawning months of the National Revolution. This was investigation of American immigration law by Nazis for Nazis. Much further investigation of the same kind took place over the following 2 years, as lawyers and bureaucrats wrestled with the political and doctrinal challenges in creating new citizenship and naturalization law. A few examples of how the legal literature described American law will give a sense of the interest in America in the German era of the early 1930s. I begin with the National Socialist Handbook for Law and Legislation. This was an immense tome published in the winter of 1934-1935 under the editorship of Hans Frank, head of the Party Office for Legal Affairs, and later Governor-General and Lord of the Nazi terror regime in occupied Poland. As the title indicates, the National Socialist Handbook was intended to mark out the path for future Nazi lawmaking. It included contributions on every aspect of the law, composed by various Nazi lawyers under Frank's direction. It is a point of some significance that the handbook made special reference to the American model more than once. National Socialist Handbook for Law and Legislation, 1934-1935. The law on the Revocation of Naturalization and the withdrawal of German citizenship of 1933 distinguishes between desirable and undesirable immigration. In this connection, it is opportune to direct the reader's attention to the fact that the difference between desirable and undesirable naturalization has played an important role in the immigration law of the United States for some years. Particularly striking is the handbook article on folk, race, and state. This was a basic review of how to craft race legislation for a new Nazi order. Authored by Herbert Kier, at the time a junior academic at the University of Berlin and later one of Heinrich Himmler's operatives. Kier devoted a full quarter of his text to the American model, reviewing the whole range of race law, including anti-miscegenation, which he described in state-by-state detail, and segregation. The very closing paragraph of his article was dedicated to American immigration law and to hailing America as the forerunner of Nazism. American immigration legislation shows that in the USA a clear understanding has been achieved that a unified North American folk body can only emerge from the melting pot if wholly foreign racial population masses are not tossed in with the core population, which is English, Scandinavian, German in origin, and thus made up of racially related peoples. These two populations, that is, the core population and the wholly foreign racial population, feel such natural antipathy that they resist being welded together. Once this fundamental recognition has been attained, it is only a matter of logical thinking to pay tribute to it in political ideology, and above all in the creation of a concept of the folk. National Socialism is the first to do this, and the time will hopefully yet come when the Volker, who are to be numbered among the European cultural circle, will acknowledge this epochal deed, which called upon them to come to their senses and remember their original and essential values. Thus the concluding words of the standard Nazi handbook chapter on how to craft race legislation. America had attained the fundamental recognition and taken the first steps. Nazi Germany was carrying the logic rigorously forward. In time it was to be hoped that all of the European culture circle would join in. Many other texts can be adduced as well, all of them painting the picture of a racist and therefore attractive American legal model, though all of them also acknowledging that America had its flaws, and many of them warning that Americans might yet backslide or decay. America was described in the standard Nazi jargon as a country founded in Gemeinschaft, the folk community. Edgar Sebisch, Der Begriff der Staatsangehörigkeit, the concept of the national as opposed to the citizen, 1934. America possesses a proud consciousness of Gemeinschaft. Any state which, like this one, adopts a posture of fundamental rejection of would-be immigrants trying to push their way in, which subjects those immigrants whom it chooses to a series of tests and confessions of loyalty, shows that it values membership in a Gemeinschaft as a precious good. This high level of self-esteem grows out of a profound national consciousness, which jealously guards its closed Gemeinschaft against new foreign intruders. It was a country committed to Nordic supremacy. Martin Staemler, Rasenpflege im Völkischen Staat, The Maintenance of Race Purity in the Völkisch State, 1935, that the Americans have begun to think about the maintenance of race purity, and thus to ask not only about eugenics, but also about membership in individual races, can be seen in their immigration laws, which completely forbid the immigration of yellows and place immigration from the individual European countries under sharp supervision, here principally admitting members of the decidedly Nordic peoples, English, German, Scandinavian states, whereas Southern and Eastern Europeans receive only a very weak portion of the admissions. The American knows very well who has made his land great. He sees that the Nordic blood is drying up and seeks to refresh that blood through his immigration legislation. It was a country whose ruling whites were determined to keep foreign elements at bay. Detlef Zahm, Die Vereinigten Staaten von Amerika und das Problem der nationalen Einheit, The United States of America and the Problem of National Unity, 1936. The legal and social position of racial minorities, as well as foreigners, is evidence of the fact that large portions of the population do not belong to the dominant circles and, indeed, stand in part in direct opposition to them. The circles of those who can trace their entry far back in American history try to protect their supremacy, Oberherrschaft, and to guarantee it for all future times. For that reason, they focus their efforts on assimilating the foreign bodies into the nation through education and preventing the influx of racially foreign elements, artfremder Elemente. The immigration and naturalization laws speak volumes about this effort. There are many such quotes. As one author put it, America was sounding the loudest warning cry about the danger of race mixing. It had produced race-based immigration legislation from which all the Nordic world should learn. The issue was, after all, one of life and death for the white race. These were more than casual references to the warning cries sounded in American immigration law. The publications of the early 1930s included lengthy and carefully documented studies of American immigration law and jurisprudence. For example, Heinrich Krieger, a young Nazi lawyer who was the single most important figure in the Nazi assimilation of American race law, dedicated 35 well-informed and thoughtful pages to American immigration and naturalization law in his important 1936 book, Das Reisenrecht in den Vereinigten Staaten, Race Law in the United States. I will return to Krieger's book and his biography in more depth in Chapter 2. Krieger was not alone. Another striking example of a Nazi closely engaging with American citizenship law is Johann von Leers. Leers was a leading so-called Jew expert involved in the earliest stages of the drafting process that led to the Nuremberg Laws. He was one of the more repellent of Nazi lawyer anti-Semites with one of the stranger careers. A member of the party from an early date, Leers escaped Germany after the war, at first to Argentina. In the 1950s, he moved to Egypt, where he became an advisor on anti-Israel propaganda to Gamal Abdel Nasser. Convinced that Christian Europe had abandoned the world historical struggle against the Jews, Leers converted to Islam, dying in Egypt in 1965 as Omar Amin. In his 1936 book-length pamphlet, Blood and Race, A Tour Through the History of Peoples, Lears devoted 23 full pages to American race law. His review included not only an account of the 14th Amendment, of Jim Crow segregation, and a state-by-state review of anti-miscegenation laws, but also 13 pages on immigration and naturalization that included detailed statistics and discussion of the law with regard to each racial minority. Certain aspects of American immigration law attracted particular interest among Nazi lawyers. Authors were intrigued by the American treatment of naturalization and denaturalization. Edgar Zabish, author of the 1934 study The Concept of the National, was certainly something of a skeptic about the United States. Nevertheless, he pointed admiringly to certain American approaches to naturalization. The rigorous attitude of American law, he noted, reveals itself in the provisions created for wartime. Even before the experience of World War I, the Americans, unlike the British and the French, had passed wise legislation denying the right of naturalization to citizens of any country with which America was at war. The same author also highlighted an American idea of particular interest for the history of the Nuremberg Laws. This was an idea found in the Cable Act of 1922, which concerned the citizenship of married women. Historically, the citizenship of wives in the Western world was subsumed in that of their husbands, but by the beginning of the 20th century, modern systems were generally rejecting that doctrine, and the Cable Act was one of a number of statutes in various countries that abrogated the historic rule. Unlike statutes elsewhere, however, the Cable Act included a race-based exception. Until 1930, the Act made a point of stripping American women of their citizenship if they were misguided enough to marry non-citizen Asian men. Zabish, unaware that that provision of the Cable Act had been repealed, saluted it as a healthy example of legislation motivated by race consciousness. If an American woman marries a Japanese man, then she does not retain her citizenship, as she would if she contracted other foreign marriages, but loses it upon marriage. This consequence is obviously meant as the well-deserved punishment for the female citizen who enters into a union with a person incapable of forming part of the Gemeinschaft. This sort of race rule, expelling women who had polluted themselves through marriage to a foreign body, was of great interest to Nazi writers. Lears identified a similar example from the Anglo-American world in his Blood and Race. If a woman of English nationality and Christian faith marries a Mohammedan who is not a British citizen, but perhaps a subject or citizen of a Mohammedan state, she loses her British nationality as a result of her marriage. And if the husband and wife take up residence in a Mohammedan land that is neither a possession nor a protectorate of His Britannic Majesty, they fall under subjection to Mohammedan law. What reader could have guessed that Lears himself would himself die as the Mohammedan Omar Amin in a Mohammedan land 30 years later? At any rate, Anglo-American practices of denaturalization upon marriage seemed to merit serious attention from Nazi policymakers, and as we shall find out, they were practices that bore some relation to an important aspect of the Nuremberg Laws. The implementation of the Nuremberg Laws focused in a similar way on marital choices. The Nazis faced the question of which half-Jewish Mischlinge, mongrels, would count as Jews by law. The answer they gave in part was that mongrels were Jews if they chose to marry other Jews, thus revealing their Jewish inclinations or the strength of their Jewish blood. Like an American woman who took a Japanese spouse, these were individuals who had chosen to associate themselves with a foreign element abhorrent to the healthy folk community. The Nazis look to American second-class citizenship. American immigration law featured especially frequently in the Nazi legal literature, perhaps because Hitler himself had praised it so demonstratively. But Nazi authors did not neglect American citizenship law, with its creation of de jure and de facto forms of second-class citizenship for blacks, Puerto Ricans, Filipinos, Chinese, and Native Americans. As Mazauer rightly guesses, this was indeed a topic of special interest in the Nazi Germany of the Second Nuremberg Law. Nazi authors of the 1930s remained especially intrigued by the de facto legal degradation of American blacks, whose citizenship they, like their German predecessors, knew to be a dead letter. In fact, the topic of black disenfranchisement in the United States seemed of sufficient political interest that it made its way into mass circulation party publications. For example, a cheap party magazine intended for a broad Nazi readership, the Essay Führer, reported on the meaninglessness of black citizenship in the United States. So did a particularly interesting 1936 article published in Neues Volk, New Folk, a propaganda newsletter produced by the National Socialist Office on Racial Policy. This striking piece of party race propaganda, which promised to explain white and black in America to the general German population, opened with a handy map of the 48 states, showing the precise status of American disenfranchisement and miscegenation law throughout the country under the heading Statutory Restrictions on Negro Rights. The article then proceeded with a breezy account of black life and history in the United States, accompanied by 7 pages of photos. It focused particularly on New York City. New York blacks, it informed its readers, maintained their own culture in Harlem by night, but by day they commuted downtown to serve as shoeshine boys and elevator operators, gleaming like patent leather and with kinky hair like lamb's wool. Some of the blacks worked as waiters in New York as well, the article reported, but they are not allowed to speak a word to the white guests and bring them the menu on a tray, not in their hand. Like other Nazi literature, this article, which carried the title How Race Questions Arise, warned that the Negro problem represented a grave threat to America. In particular, it noted rising black birth rates, while its illustrations included reproductions of advertisements for skin lightening cream and hair straightening pomade, products that blacks might use to disguise their gleaming skin and lamb's wool hair in order to penetrate white society. Nevertheless, the article emphasized that Americans were taking healthy measures to combat the race danger that they faced, just as Nazis were doing, even if a certain part of the American press was hostile to National Socialism. The United States, too, just like Nazi Germany, has racist politics and policies. What is lynch justice if not the natural resistance of the folk to an alien race that is attempting to gain the upper hand? Most states of the Union have special laws directed against the Negroes, which limit their voting rights, freedom of movement, and career possibilities. For a while, there was a plan to create a Negro reservation in the southern states, similar to the Indian reservations. There is no way of guessing where the authors of the article picked up the odd notion that America had planned a Negro reservation. South Africa had such reservations, as Lears observed, but the United States did not. In any case, the article shows that in 1936, as the Nuremberg Laws took hold, Nazi Party officials were making an effort to publicize the American method of creating de facto second-class citizenship to average Germans on the street, at a time when Germany, too, was subjecting its Jews to racist politics and policy. This was propaganda, but it was propaganda directed at the home population, not at foreign critics. Meanwhile, the technical legal literature continued to explicate the law of American second-class citizenship, just as the German literature had done in earlier decades. The United States, a 1933 book reported, had invented for its subject populations a novel intermediate category between citizenship and statelessness, an unprecedented form of legal limbo. This novel category covered not only blacks, but also the subject populations of Filipinos and Puerto Ricans. Krieger, in a much-cited 1934 article that would be influential on the internal deliberations over the drafting of the Blood Law, pointed out that not only blacks, but also Chinese were deprived of meaningful voting rights in the United States. Deutsche Justiz, a leading party organ on legal affairs, highlighted the same fact. "The Negroes are not equal before the law," wrote one author in a 1935 book touting John C. Calhoun as a racist inspiration for Germany. And they could never be made equal because full political equality would obviously put an end to the sexual separation between the races, and the healthy race instinct of the Anglo-Saxons has so far rejected that. It is particularly noteworthy that Nazi authors of the early 1930s saw clear parallels between the American Negro problem and their own Jewish problem. It is simply false to assert, as scholars have done, that America was of no interest to Nazi Germany because the Jews were not expressly persecuted there. For example, the same admirer of John C. Calhoun judged that the only desperate hope of America lay in mass deportation of the blacks, just as the only desperate hope of the Germans lay in the Zionist movement. More importantly, the technical legal literature saw the same parallels. From the point of view of Nazi lawyers in the early 1930s, the Jewish problem that Germany faced was first and foremost a problem of Jewish influence, particularly in government, bureaucracy, and law. It was for that reason that the party program of 1920 included its point 6. 6. Only a citizen is permitted the right to decide on the leadership, Führung, and laws of the state. Therefore, we demand that every public office, regardless of what kind, regardless of whether it is an office of the Reich, of the constituent states of the Reich, or any municipality, be accessible only to citizens. It was for the same reason that the earliest Nazi anti-Jewish legislation set out to exclude Jews from government, universities, and the legal profession. And when Nazi lawyers considered the American deprivation of black rights, they saw, bizarrely, a precisely parallel effort to combat black influence. For them, American blacks were not a desperately oppressed and impoverished population, but a menacing alien race of invaders that threatened to get the upper hand and therefore had to be thwarted. This lunatic view, it should be said, was one that Nazis shared with American racists. Krieger's influential 1934 article explained that it was because the ruling race in America had to work to prevent black influence that American lawyers had developed covert legal subterfuges to deprive the black population of full political rights, despite their notional constitutionally guaranteed citizenship. The article went into considerable detail about how these subterfuges functioned, and expressed cautious optimism that America would eventually move toward a more open form of legal racism of the kind being developed at home in Germany. Zahm similarly surveyed the techniques of the deprivation of black political rights, which were designed to depress the political influence of the Negroes to a minimum in the southern states. Germans saw the same issues in the status of American Jews. Thus, Zahm explained that American Jews, while technically suffering no legal disabilities, were relegated to a subordinate social position through non-legal means such as university quotas. The respectable legal profession in particular remained closed to them. In this manner, the United States was working to keep its Jews at bay without formally abrogating their constitutional protections. Lears thought the same thing, though he was sure that mere custom was inadequate to stave off the dangers posed by Jews. Formal law was needed. Zahm is a particularly noteworthy author since he put special care into examining American law in ways that brought out its resemblances to the new law of the Reich. Hitler had written in Mein Kampf that the Völkisch state divides its inhabitants into three classes: Staatsbürger, citizens, Staatsangehörige, nationals, and Ausländer, aliens. Zahm, without citing the Führer expressly, explained to his German readers that American law followed the canonical Mein Kampf model precisely. American public law distinguishes between Staatsbürger, citizens, Staatsangehörige, nationals, and Ausländer, aliens. Staatsbürgerschaft, citizenship, is the highest legal level. One becomes an American citizen by birth or through naturalization. Alongside the citizens, there are also nationals who do not enjoy the rights of citizenship, non-citizen nationals. Such nationals include most inhabitants of the Philippines, while inhabitants of Hawaii, Puerto Rico, the Virgin Islands also possess American citizenship. The Nuremberg Laws declared that only citizens enjoyed full political rights. American law, Zahm observed, had a parallel rule distinguishing between political rights and civil rights. Zahm emphasized that American law further guaranteed that certain groups who technically possessed political rights were nevertheless excluded from voting. The disfavored groups included not only blacks, but also Native Americans. As for aliens, they faced a variety of disabilities under American law, a matter of natural interest to the Nazis, who since 1920 had been insisting that foreigners must benefit only from limited guest right. By such means, the Americans, as Drascher wrote in his Supremacy of the White Race, took care to guarantee that the decisive positions in the leadership, Führung, of the state would be kept in the hands of Anglo-Saxons alone. Once again, it was not only the Nazis who found these American developments fascinating. Throughout Europe, it was a commonplace in the 1930s and 1940s that the South, through its systematic deprivation of the voting rights of blacks and Mexicans and Native Americans, had embarked on the creation of something that looked unmistakably like the American version of a race-based fascist order. The Ku Klux Klan are the fascists of America, a French author reported. They were a group founded in order to combat black enfranchisement. Bertram Schrike, a Dutch ethnographer who published an interesting book on American race relations in 1936, declared that the Southern process of undoing Reconstruction, with its violence, intimidation, open bribery, stuffing ballot boxes, manipulation and falsification of election returns, use of tissue ballots, etc., all serving to eliminate Negro voters, reminds one strongly of the rise of the Nazis in Germany. On account of its one-party system and the precarious state of civil liberties, wrote Gunnar Myrdal in 1944, the South is sometimes referred to as fascist. Nevertheless, if Europeans widely shared this thought, it is especially striking to discover Nazis themselves expressing it, declaring, as Krieger did, that the Democratic Party of the South, through its racist election law, had built a one-party system, and that the only remaining question was whether it would succeed, as the Nazis had done, in making the party an organ of the state. Conclusion. All this Nazi lionization of white supremacy in America, and all this Nazi rummaging in American immigration and citizenship law, requires some careful assessment and some careful choice of words. The Nazis were clearly deeply interested in the American example, but it would be a mistake to draw overblown conclusions about the direct influence of the American model on the citizenship law. There was never any possibility that the Nazis would copy the citizenship law directly from what they found in American parallels, no matter how much they praised them. America may have been the global leader in the creation of racist law, well known and much cited long before Hitler came to power, but as the Nazis regularly observed, American law was not open about its racist goals, at least when it came to citizenship and immigration. We shall hear in the next chapter that American anti-miscegenation law was quite different. In their citizenship and immigration law, Americans had to work around the requirements of the 14th Amendment, and more broadly around their announced traditions of equality, and in consequence their law was a law of covert devices and legal subterfuges. American law, as Krieger wrote, was a law of Umwege, devious legal pathways. The Nazis certainly found this American juristic mischief engaging, and they were glad for the chance to point out the depth of American legal racism, both in party propaganda and in the technical legal literature. But for their part, they fully intended to create an open system of racist citizenship, and if for no other reason, then they had no need to borrow from the letter of American law. Nazi race law was not going to be a law of national quotas, poll taxes, grandfather clauses, or literacy tests. In any case, it is inherently unlikely that we would discover unmodified borrowing. Nazi jurists were German lawyers, the representatives of a deep and proud juristic tradition, one that generally exported law to other countries, not one that mechanically borrowed. What is more, they were German lawyers who were convinced that they were participating in a national revolution that represented a breakthrough in human history. It would be surprising indeed if these men had simply aped American law, and they did not do so. So it would be wrong to say that the Nazis directly borrowed from the Americans in the making of the citizenship law. This is not a story of what, in the jargon of comparative law, would be called an American transplant into Nazi Germany. At the same time, it would be foolish and craven to minimize Nazi interest in what American law represented. From Mein Kampf on, the Nazis did indeed lionize American white supremacy and did indeed rummage in American immigration and citizenship law. The National Socialist Handbook did indeed describe America as the country that had achieved the fundamental recognition of the historic racist mission that Nazi Germany was now called to fulfill. In that sense, the legal literature was entirely in tune with the historical literature that announced that until the coming of Hitler, the United States had held the leadership of the white peoples in the Aryan struggle for world domination. If Nazi legal authors believed that American race legislation was highly imperfect and therefore deserving of reproach, if they derided the activities of New York Jews like Louis Brodsky, they nevertheless thought of the United States as a country groping its way toward the policies of a healthy, folkish order, in obedience to the healthy American race consciousness, as the country that had, in the view of Mein Kampf, taken the first steps. So if there was no direct borrowing from America in the citizenship law, there was nevertheless something whose importance for the mentality of Nazi lawyers and policymakers should not be dismissed. In immigration and citizenship, the American example served not so much as a direct template, but as welcome evidence that race consciousness had already begun to shape the law in a leading Nordic polity. But it did serve as welcome evidence, and it would be wrong to underestimate the importance of that fact. American law offered the Nazis something that matters a great deal to modern lawyers. It offered them confirmation that the winds of history were blowing in their direction. Their America was what Hitler described it to be, a dynamic country whose race consciousness had stirred the first substantial moves toward the sort of race order that it was Germany's mission to bring to full fruition. Comparative law influence is not just a matter of lifting particular regulations, copying particular paragraphs, or transplanting particular institutions. Lawyers, even Nazi lawyers, need a sense of the propriety and necessity of their law, and the presence of foreign parallels can provide salutary comfort and inspiration. Modern lawyers, in particular, often want to believe that they are soldiering toward a better future, and evidence that other countries are soldiering toward the same better future, in however bumbling a way, matters to them. This is perhaps especially true of lawyers plunged into a self-consciously revolutionary situation. And painful though it may be for us to admit it, it is not surprising that these lawyer participants in the Nazi national revolution, like far-right wingers before them, seized on the American example. American race-based immigration and citizenship law did, in fact, set the standard in the early 20th century. The Nazi case suggests how much truth there is in the verdict that the United States was the leader in developing explicitly racist policies of nationality and immigration. This was a realm in which the creative legal culture of the United States set the international tone in the early 20th century, much as it sets the tone in areas like corporate law today. That is why even Nazi Germany looked to America. Still, what we discover in the making of the citizenship law cannot rightly be called borrowing. If we are to hunt for more provocative evidence of something that looks more like borrowing, we must turn to its companion measure, the blood law.